Item 13. 30. Yeah, bring. You are Mr.
Yeah.
On request made by Mr. D.N. Bhattacharya, London Council of the Petitioner. Reached the matter after 2 weeks. Mike.
Also, I beg to mention a pending matter, my lords, for listing of 2000. It's a 2022 matter. It's very small matter, my lords. Any time, any date convenient to my lordship, my lords.
Is a hearing matter.
No, my lords, for admission.
12.
Well, deeply over.
Okay. 5th.
May it please your lordship. Lordship, in regard to item number 13 of the daily list. Lordship, may I pray for an adjournment in this case, Lordship, for today? Because in this case, Lordship, my senior Mr. DC Counsel will be leading me, Lordship, and he, due to some difficulty, he could not turn up to the court today. Can it be on 25th of June, Lordship? The long pending matter, we have also some urgency, but only for today.
You are adjourning the matter. How can you? How do you want a date fixed?
Lordship, if your Lordship pleases, Lordship, because
Okay, on request made on behalf of Mr. BC Das, then the council. This is the matter on
25th of June, Lordship, it is
Okay.
convenient. Deeply obliged.
Wait, legal lordship. Item number 1.
Item?
Content of the other side.
item.
Item number 1.
Oh,
Lordship, I appear for the petition in the matter, Lordship. Otherwise, our submissions were complete. The respondents were supposed to reply.
yeah, what do you want?
You want the recommend for today, your lordship. Can it be on the side?
Put on the mic. Put the mic on.
We wanted adjournment for today, your lordship. So Tiwari is out of station, your lordship. Last time he had approached you about the date also, your lordship. Can it be next week, your lordship? Last accommodation for today.
Okay, heard Mr.
And Gautam.
And Gautam and the council. On request made on behalf of Mr. P. Tiwari, the senior counsel for the respondents. 2 to 4
Sixth, your lordship. Can it be on sixth?
is the matter.
Lordship. Lordship.
Obliged, your lordship.
May it please, your lordship. Your lordship, I've sought the consent of my senior friend for the higher education. I'd like to mention item number 19, 20, and 21. The matters are tagged. The issue pertains to regularization of teachers in various provincialized colleges. Your lordship, we have some difficulty today. As per your lordship's convenience, if your lordship fixes it on any day in the month of June, your lordship will be pleased to conduct the matter, your lordship. As per your lordship's convenience.
Okay, on request made by Mr.
M. Sharma, your lordship.
M. Sharma, then the council for the petitioner.
For the petitioners, your lordship, in all the writ petitions. In all the writ.
When do you want?
I'll leave it to your lordship. Since you're taking a time today, I will not constrain your lordship with a date, but your lordship can fix any date, your lordship. It will be
Okay, 20.
20. I'm grateful, your lordship. I'm grateful.
May we please your lordship? WPC number 1255/24. Lordship, kindly be pleased to fix on 3rd June.
Why 3rd June?
Actually, lordship, it's a pension benefit matter. That's it.
We'll have it on 12th. 12th June.
Yes.
May I feel your listen? My lord, I beg to mention item number 3, 4, and 5, my lord. Take matter. I am for the 3 and 5, my lord.
Oh.
My senior is 4, my lord. Today, my lord, as Borago is some difficulty, my lord. So I prefer pass over for a day.
Okay. On request made by Mr.
D Google, my lord.
D. Gogoi, then counsel for the petitioner in WBC number
WBC number, my lord.
100 of 2022.
And my lord 1996 2024.
Just one. List these matters after 1 week.
And my senior is upper item 4.
I'm item number 4.
Lordship, highly obliged.
May it please your lordship, I beg to mention for listing of a writ petition in the admission column, your lordship. My lord may kindly take it up on Wednesday, if possible, your lordship.
Wait, many cases are listed. We'll have it on 12th.
Much obliged, your lordship.
May I please your lordship, I beg to mention for listing of a case, matter relating to, drop of teacher, drop of.
14th.
Obliged.
My lord, prayer for listing the contempt case next week, sir, my lord.
Why next week?
So this is regarding contempt case for consideration of service of teachers.
Okay. 12.
Thank you.
May I please, the lord? So, my lord, I beg to mention for listing of a pending writ petition, my lord, next week, my lord, or Tuesday or Thursday.
This is a hearing matter.
No, my lord, it is an admission stage, my lord.
6th.
My lord. Obliged.
Item 34 of supplementary motion.
My lord, can it be possible for timing standing counsel requested me as he is late in another court, my lord? NMC. Oblige, your lordship.
Two of daily admission, part one matter.
May it please, lordship. On the last occasion, my lord, I have brought your lordship's attention to the facts of the case. Brief fact is that, my lord, the petitioner before lordship was denied the promotion on the basis of some ACRs, adverse ACRs, which were not communicated to him. And well, but on the due to paucity of time, the judgments could not be placed before lordship on the last occasion. I have given the compilation of judgments.
Yes. Why so many judgments?
Well, first two judgments, my lord, on the point of, my lord, when a writ can be issued. When the authority, my lord, they cannot discharge their, my lord, duties on the basis of their statutory guidelines, then your lordship has the authority to my lord, issue writ. First two judgments, my lord. The other judgments are, my lord, on the point of communication. This says that, my lord, the communication was not in vague prior to 2010. But in Amarkant Chaudhary, those will find page 47, paragraph 9.
Yes.
May I read, madam? Before concluding, we wish to state that the central government and the state government should now examine whether the present system of maintenance of confidential role should be continued. Under the present system, entries are first made in the confidential role of an officer behind his back, and when he is given an opportunity to make a representation against any entry behind his back, entry that may have been made against him by communicating the adverse entry after considerable delay, any representation made by him should be considered by a higher authority or the state government or the central government, as the case may be, some years later, as it happened in this case, by which time any evidence that may have that may be there to show that the entries made were baseless may have vanished. The predicament in which the officer against whom adverse remarks are made is then placed can easily be visualized. Even the authority which has got to pass orders or on representation of the officer will find it difficult to deal with the matter satisfactorily after a long interval of time. In the meantime, the officer concerned would have missed many opportunities which would have advanced his prospects in the service. In order to avoid such contingency, the government may consider the introduction of system in which the officer who has to make entries in the confidential roll may be required to record his remarks in presence of the officer against whom remarks are proposed to be made, after giving him an opportunity to explain any circumstance that may appear to be against him, with the right to make intake representation to higher authorities against any adverse remarks. This course may obviate many times totally baseless remarks being made in the confidential role, and would minimize the unnecessary suffering to which the officer concerned will be exposed. Another system which may be introduced is to ask the officer who records the confidential remark to serve a copy of such remark on the officer concerned before the confidential rule is submitted to the higher authority, so that his representation against the remarks may also reach the higher authority shortly after the confidential rule is received. This would curtail the delay in taking action on the representation. Suspension, adverse remarks in the confidential role, and frequent transfer from one place to another are ordered or made many a time without justification and without giving reasonable opportunity to the officer concerned, and such actions surely result in demoralization of services. Courts can give very little relief in such cases. The executive itself should therefore devise effective means to mitigate the hardship caused to the officer who are subjected to such treatment. These questions required to be examined afresh in the light of experience gained in recent years, and solutions should be found to eliminate as far as possible complaints against misuse of these powers by official superiors who may not be well disposed towards the officer against whom such action is taken. It is needless to state that disgruntled bureaucracy adds to the efficiency of administration. Well, by this judgment, the Honorable Court suggested the authority, directed the authority, union and state, to devise a measure so that the officer against whom the adverse entries are made is aware about the entries prior to making such entries in the confidential room. But what they have done, they have communicated the entries and adverse entries. They have only the numerical grades they communicated. In the first ACR, my lord, they have given the numerical grades of IO only. In the second ACR, IO and RO numerical grades. Other remarks they have not given. But that too, my lord, without, my lord, making the officer know about the loopholes during his service. Because, my lord, prior to the reporting period, his performance was outstanding. Immediately prior to the reporting period, my lord, very good. Very good. And immediately after the reporting period also, my lord, very good. This reporting period is, my lord, 2005, 2006 into my lord, this year, 2006 and 2007. But prior to that, 2004, 5, 7, 8, and 8, 9. 4, 5 is part good and part very good. 7, 8 is very good, and 8, 9 is good. If the officer, my lord, could not perform during the reporting period, they should have immediately informed the officer, my lord, his loopholes. But they have given 2 letters, my lord, in their affidavit, saying that those letters are the performance counseling letters. If your lordship peruses those letters, this is not a performance counseling letter. These are, my lord, only administrative direction. I was directed to sign in a, my lord, particular document, which I did not, because the superior authority, my lord, who was required to sign those documents, he did not sign that document, and I was directed to sign that document. I was not authorized to sign that document. That is why I could not sign. And for that, my lord, some letter was given to the petitioner, and during the first reporting period only, my lord, The second reporting period, there is no such performance counseling. My lord, on point of assessment, my lord, how the assessment is to be made, my lord, page 55, paragraph 11 of S. Ramachandra Raju, my lord. Paragraph 11, my lord. The facts are eloquent. From 1973-74, the appellant started with a communication of his performance to be satisfactory to fair in the year 1990-91. Would it be comprehensible that in the year 1987-88, whether he would suddenly drop down and become an average or below average teacher when he was a responsible teacher and he did cordial relation with the student community and was taking pains to impart lesson to the students, would it be believable that he avoids to take classes and drops down if not what's when anterior to or subsequent to 87-88, he was a man of ability, of integrity. The same would become below average only for the academic year 87-88 without discernible reasons. It would speak volumes on the objectivity of assessment by the reporting officer, that is the principal. This conduct is much to be desired. This case would establish as a stark reality that writing confidential report bears onerous responsibility on the reporting officer to eschew his subjectivity and personal prejudices or proclivity on or predilections and to make objective assessment. It is needless to emphasize that the career prospects of a subordinate officer employee largely depends upon the work and character assessment by the reporting officer. The latter should adopt fair, objective, dispassionate, and constructive comments in the estimating or assessing the character, ability, integrity, and responsibility displayed by the officer employee concerned during the relevant period for the above objectives, if not strictly adhered to in making an honest assessment, the prospect and career of the subordinate officer being put to great jeopardy. The reporting officer is bound to lose his credibility in the eyes of his subordinate and fail to command respect and work from them. The confidential and statutory safeguards given to the government employees largely become responsible to display carelessness and disregard of the discharge of their duties and make it impossible to the superior or controlling officers to extract legitimate work from them. The writing of confidentials in contributing to make the subordinates work at least to some extent. Therefore, writing the confidential report objectively and constructively and communications thereof at the earliest would pave the way for amends by airing subordinate officer or to improve the efficiency in service. At the same time, the subordinate employee officer should dedicate to do hard work and assiduity in the discharge of the duty, honesty, and integrity in performance thereof, which alone would earn his usefulness in retention of his service. Both would contribute to improve the excellence in service. In the instant case also, my lord, prior to the reporting period, impugned reporting period, and after the impugned reporting period, the performance of the petitioner was either good or very good. Only for the impugned reporting period, how he deteriorated his performance, that was not, my lord, supported by any reasons in the ACRs, impugned ACRs. And this judgment also says that, my lord, that ACR should be communicated immediately so that the officer concerned is aware of his mistakes and he can amend his mistakes by performing better in the next reporting period. Then let us read Devdutt, my lord. Paragraph 36. Page, my lord, it starts from page 59. 36 is my lord, I'll read some relevant paragraphs from this judgment, my lord, because my lord, Devdutt is the judgment from which, my lord, the issue of ACR has been, my lord, decided by the Honorable Apex Court. So, my lord, it starts from page 59. I'll draw your lordship attention to paragraph 7 at page 64. Has your lordship?
Yes.
Case, my lord, 64. Paragraph 7, my lord. In reply, learned counsel for the respondent submitted that a good entry is not an adverse entry, and it is only an adverse entry which has to be communicated to an employee. It is their admission, my lord. The same department, my lord. If I am permitted to say, my lord, Devdutt was also an employee of DEF. Of the my lord, Borders organization. Borders organization, my lord. The petitioner is also working under the Borders organization, my lord. And my lord, Borders organization says the only the adverse entries are communicable, not the good entry. My entry, my lord, impugn entries are average entry. That they also, my lord, admits that that is adverse entry. And they should have communicated in, my lord, as per their own version before the Honorable Apex Court. Hence, he submitted that there was no illegality in not communicating the good entry to the appellant. Now, paragraph 10, my lord, page 65. Hence, in our opinion, the good entry should have been communicated to the appellant so as to enable him to make a representation praying that the said entry for the year 1993-94 should be upgraded from good to very good. Of course, after considering such a representation, it was open to the authority concerned to reject the representation and confirm the good entry, but at least an opportunity of making such representation should have been given to the appellant, and that would only have been possible had the appellant been communicated the good entry, which was not done in this case. Hence, we are of the opinion that the non-communication of the good entry was arbitrary, hence illegal, and the decision relied upon by the learned counsel for the respondent are distinguishable. The learned counsel, paragraph 11, my lord, learned counsel for the respondent submitted that the under office memorandum dated number so and so, only an adverse entry is to be communicated to the employee concerned. It is well settled that no rule of government instruction can violate Article 14 or any other provisions of Constitution, as the Constitution is the highest law of the land. The aforesaid office memorandum, if it is interpreted to mean that only adverse entries are to be communicated to the employee concerned and not other entries, would in our opinion become arbitrary and hence illegal, being violative of Article 14. All similar rules, government orders, office memorandum in respect of the services of under a state, whether civil, judicial, police, or other service except the military, will hence also be illegal and are therefore liable to be ignored. Paragraph 12, my lord. It has been held in Maneka Gandhi versus Union of India that arbitrariness violates Article 14 of the Constitution. In our opinion, the non-communication of an entry in ACR by public servant is arbitrary because it deprives the employee concerned for making a representation against it and praying for its upgradation. In our opinion, every entry in the annual confidential report of every employee under the state, whether he is civil, judicial, police, or other service except military, must be communicated to him so as to enable him to make a representation against it. Because non-communication deprives the employee of the opportunity of making a representation against it, which may affect his chances of being promoted. Moreover, the object of writing the confidential report and making entries in the index is to give the opportunity to the public servant to improve his performance by UP versus Yamuna Shankar Mishra. Hence, non-communication is, in our opinion, arbitrary and hence violative of Article 40 of the Constitution. In our opinion, paragraph 13, Malab, every entry and not merely the poor or adverse entry relating to an employee under the state or an instrumentality of the state, whether civil, judicial, police, or other, must be communicated to him within a reasonable period, and it makes no difference whether there is a benchmark or not. Even if there is no benchmark, non-communication of an entry may adversely affect the employee's chances of promotion, because when comparative merit is being considered for promotion, a person having good or average or fair entry certainly has less chances of being selected than a person having very good or outstanding entry. Next, paragraph 17, my lord. Page 67.
Yes.
In our opinion, every entry in ACR of a public servant must be communicated to him within a reasonable period, whether it is poor, fair, average, good, or very good entry. This is because non-communication of such entry may adversely affect the employee in two ways. Had the entry been communicated to him, he would know about the assessment of his work and conduct by his superior, which would enable him to improve his work in future. He would have an opportunity to making a representation against the entry if he feels it is justified and pray for its upgradation. Hence, non-communication of an entry is arbitrary, and it has been held by the Constitution bench the decision of this court in Maneka Gandhi versus so that arbitrariness violates Article 14 of the Constitution. Next, Lordship may turn to page 71, my lord. Paragraph 36. In the present case, we are developing the principles of natural justice by holding that fairness and transparency in public administration requires that all entries in the annual confidential report of a public servant, whether in civil, police, or any other state service, must be communicated to him within a reasonable period so that he can make a representation for its upgradation. This is our opinion in the correct legal position, even though there may be no rule GO requiring communication of the entry, or even if there is no rule GO prohibiting it, because the principle of non-arbitrariness in the state action is envisaged by Article 14 of the Constitution. In our opinion, requires such communications. Article 14 will override all the rules or government orders. Paragraph 37. We further hold that when the entry is communicated to him, the public servant should have a right to make a representation against the entry to the authority concerned, and the authority concerned must decide the representation in a fair and within a reasonable period. We also hold that representation must be decided by an authority higher than the one who gave the entry. Otherwise, the likelihood is that the representation will be summarily rejected without adequate consideration, as it would be an appeal from seizure to seizure. All this would be conducive to the fairness and transparency in public administration and would result in fairness to public servants. The state must be a model employer and must act fairly towards its employee. Only then would good governance be possible. Then next page, my lord, paragraph 41. Concluding paragraphs, my lord. In our opinion, non-communication of entries in annual confidential report of a public servant, whether he is civil so and so, certainly has civil consequences because it may affect his chances for promotion to get other benefits. Hence, such non-communication would be arbitrary and such violative of Article 14 of the Constitution. In this case, paragraph 43, my lord, we are informed that the appellant has already retired from service. However, if his representation for upgradation of the good entry is allowed, he may benefit in suspension and get some arrears. Hence, we direct that good entry so and so communicated to the appellant forthwith and it would be permitted. And this is just for only for the purpose of communication. Now, Lordship may kindly turn to page 75. Abhijit Ghosh Dasita. This was a judgment by which, my lord, the apex court held that, my lord, if adverse ACRs are not communicated, then those ACRs cannot be considered while considering the case of the officer, my lord, for promotion to the next higher post. Page 75, paragraph 8 and 9, my lord. Coming to the second aspect, that though the benchmark very good is required for being considered for promotion, admittedly, the entry of good was not communicated to the appellant. The entry of good should have been communicated to him as he was having very good in the previous year. In those circumstances, in our opinion, non-communication of the entries in the annual confidential report of the public servant, whether he is in judicial so and so, it has civil consequences because it may affect his chances of promotion or getting other benefits. Hence, such non-communication would be arbitrary and as such violative of Article 14 of the Constitution. The same view has been reiterated in the above referred decision of the so and so. Therefore, the entries good, if at all granted to the appellant, the same should not have been taken into consideration for being considered for promotion to the higher grade. The respondent has no case that the appellant had ever been informed of the nature of grading given to him. So, this is the judgment by which the apex court held that if adverse ACRs are not communicated, those ACRs cannot be considered while his case is considered for promotion. In the instant case, even, my lord, they have considered my adverse ACRs, which was not communicated to me. The PC was held prior to the communication of the adverse ACRs.
DPC was held on 29/6.
Yes, my lord. 29/6 DPC was held and it was communicated. The adverse ACRs were communicated, my lord, 8/7 on the same year. 29/6/2010 DPC was declared. And communication was 8/7/2010.
No, you received it on 8/7.
Yes, yes.
It was communicated on 18/6/2010,
Yes,
correct?
yes, my lord. But when I received, my lord, then only I will know about the contents of the ACR, my lord. So, my lord, communication is 8/7. It was communicated to me on 8/7. I was aware of the ACRs. Other judgments are also on the same footing, my lord. Judgments of this honorable court as well as the Honorable Apex Court. In the case of Dipsan, your lordships also, my lord, held that, my lord, without communicating the adverse ACRs, one cannot be denied the promotion. And authority was directed to consider the case of the petitioner with retrospective effect on the date when his juniors were promoted. Very recent judgment is there, my lord. On no, it is Supreme Court. Two loose judgments I submitted on the last occasion.
Loose judgments.
Yes, my lord. One is, my lord, MR Shah and my lord, RK Jivanlata Devi versus High Court of Manipur. And the other is, my lord, Rukhsana Sahin Khan. If it is not there, I am submitting it again, my lord, but I have got only one copy.
Yeah. What is it? Imar Shah?
RK Jivanlata Devi
Hmm.
and the other is Rukhsana Sahin Khan.
Rukhsana is not here.
One single page judgment, my lord, Rukhsana Sahin Khan. I'm submitting it, my lord, again, my lord.
Jivan Lada is there.
Lordship got the Jivanlata, my lord.
Yes.
Single page judgment on the basis of, my lord, Abhijit Dastidar and Jivanlata, my lord. That, my lord, uncommunicated adverse ACRs cannot be considered while cases of government servant is considered for promotion. And in a nutshell, my lord, the petitioner before lordship, he was denied promotion on the basis of the adverse ACRs, which were not communicated. He was, as per the seniority list, my lord, if you lordships, there was the seniority list at page 91.
Page?
Page 91.
Yes.
I was at serial number 4. And juniors were promoted, my lord, page 94. B, C, D, E, all are junior, man. They were placed at 5, 6, 7, 8 in the seniority list.
Except A.
My lord. So, my lord, lordship may direct the authority, my lord, to hold the review DPC, and the petitioner may be directed to be promoted with retrospective effect from the date, my lord, on which his juniors are promoted. This is my humble submission before lordship.
Where's the guideline?
Guideline also will find
Page,
page 28, my lord. In the guideline also, my lord, time frame was stipulated.
page 20.
Page 20, it starts from page 28. And the time frame has been stipulated at page 38. Chapter 5, my lord. Page 38. And Annexure 3
So
is
the guideline starts from page.
page 28.
Okay. Thirty-eight.
38 is the, my lord, chapter 5 is timely completion of annual performance assessment report. And it says about, my lord, Annexure 3. Annexure 3 also will find at page 47.
Yes.
No.
So you were communicated after.
The DPC was held.
The average of 2005, 2006
Yes, my lord.
and 2006, 2007.
Yes, my lord.
They both are average.
Both are average.
Both are
Yes.
average.
You received it on 8/7/2010.
My lord.
Who is that page?
With 67.
Communication is page 67, my lord. Both the ACRs were communicated together, my lord. Page 68 is the receipt, my lord. Page 68 is the receipt, my lord. I have received it on, my lord, 8 July 2010.
AO is what?
Accepting officer.
Accepting. So this was after a lapse of about 5 years.
Yes, ma'am.
Correct.
Which one? Which one?
The communication of the ACR, adverse ACR.
My lord, fact, my lord, there are two things, my lord, in the ACR, my lord. There is one thing called adverse remarks in the ACR. And another thing is, my lord, the below benchmark grading, that is average, good, bad. You know, so far as the adverse remarks in the ACR is concerned, my lord, this was pertaining to the year 2005, 6 and 6, 7.
Oh.
That adverse remarks, my lord, were already communicated to the petitioners way back in the year 2007.
Where is that?
My lord, that is, I filed the additional affidavit, my lord. There is a distinction between the two things, my lord.
1 minute.
My lord.
Yes.
My lord, will take page 245 of the additional affidavit, my lord, which we have filed.
My lord, before my friend, my lord, submits on that affidavit, my lord, this affidavit was, my lord, on the last occasion when he, my lord, lordship heard the matter in part. My friend, my lord, took leave to file the affidavit on affidavit only by annexing the, my lord, memorandum of 1985. But my lord, he has added some more documents without leave of this honorable court, my lord, during
No.
the course of hearing.
That leave was taken, my lord, that is
Yes.
why I have filed those documents.
During the course of hearing, my lord, without leave of this honorable court, they have taken these documents.
My learned friend is disputing those documents, my lord, he can reply to that, otherwise.
Then you can file a reply.
Reply.
No, I am not going to file reply, my lord. I admit
My
that,
lord,
my lord, those entries were communicated, only,
are all
only,
records, my
only
lord.
the numerical grades given by the IO for 1 year and the numerical grades given by the IO and RO for the other reporting period. The entire ACR and the remarks,
RO is the reporting authority.
my lord,
IO is the
initiating officer.
initiating officer. Yes.
But the comments given by the reporting initiating officer as well as the reporting officer was not communicated to the petitioner during that, along with that, my lord, numerical grades. So, my lord, I'm not required to file any reply to this because my apex could help that the entire ACR is to be communicated. They cannot, my lord, communicate it in piecemeal, my lord.
No, to that doubt, submit, my lord, it is only the adverse remarks. My lord, there are three.
Saikia, will it not be advisable to file a small reply here?
I'll file it, my lord.
You file a small
My
reply.
lord, my lord.
I'll give you a week's time or something like
Well,
that. File a small reply.
Then, okay, I'll file it.
It will be better for
I'll
you.
file it. I'll have to call my.
Let him file.
My lord. Otherwise, my lord, these are records, my lord, part of the records, my lord. That's why. we
No, no,
serve
but
the-
then he's saying, what he's saying is that the gradings that were given,
Yes,
that was only communicated.
only numerical grades were communicated.
Numerical grades were.
Well, there are two things, my lord. So far as adverse remarks are concerned, it is only the adverse remark, my lord, which has to be communicated. Not, my lord, all the three officers are there, my lord. The assessing officer, reporting officer, and the IO, my lord. They all assess the ACR, my lord, and it is
What
only
is the benchmark?
benchmark is good, my lord.
Good.
Good, but
So average,
in for the 2 period, my lord, out of the 5 periods, my lord, which his ACR was assessed, 2004, 5, 5, 6, 6, 7, my lord, 7, 8, and 8, 9. Those 5, 6, and 6, 7, my lord, average. For that reason, my lord, the matter could not be, he could not be promoted, my lord. But it is not only the, my lord, the adverse entries in the ACR which the DPC, the Departmental Promotion Committee, my lord, knows, my lord, can take overall assessment. It is, they are not influenced by the remark, my lord. Under the, my lord, I will
no,
produce.
no, whatever it is,
No, no.
they will be influenced by the remarks.
Yes. And so far as, my lord,
Once the petitioner does not have the benchmark,
Yes, my lord.
yes,
then obviously they will be influenced.
I will be rendered to be unfit, my lord.
yes.
If
Then
I,
you file a reply here.
yes, my lord.
Mr. IS cycle and conflict petition. It's allowed 1 week time.
One
It's allowed a week's time
next Thursday.
to file reply to the additional affidavit filed by the respondent. Stop. When do you want?
Next Thursday, my lord, on 6th.
6. Is the matter on 6. That day we can dispose of the matter.
My lord.
No.
God bless, my lord.
Six.
May I appeal, your lordship?
My lord, this matter, my lord, pertaining to the post of assistant professor.
Please, your lordship, I am appearing on behalf of six lordship. Today we are going to file our wakalatnama, lordship. Today we are going to file our
Last occasion, they said the pleadings are complete.
Yes, lordship,
Lordship,
but we have.
My lord, so far, respondent number 6,
Hmm.
I appear on 22nd, my lord, 8/2023. There is a specific order. Now today saying,
Lordship.
file.
Yes, lordship.
Enter appearance on 22nd, 8,
What
2023.
minute? Yes.
Yes, lordship, today I have engaged by her lordship. Today we will file our wakalatnama, lordship. Can it be 2 weeks time to file our response, lordship? The last,
Any response has come, not come.
no, lord.
R6.
Respondent number 6 is waiting, lordship. We are going to file our.
But her contention already pleaded by the university. Respondent number 1 to
Okay,
6.
anyway, says she has a right to file an affidavit.
Yes.
Okay, heard Mr.
Here.
K. Bhuyanandana counsel.
1 week time may be given.
I am appearing on behalf of 6, U Sharma, lordship.
Mr. U. Sharma, learned counsel. Enters appearance on behalf of respondent number 6. And prays for 1 week time will do?
2 weeks time may be given, lordship. As soon as we receive the
Press
all
for
entire copies,
2 weeks
lordship.
time to file contract. Prayers stopped. Restart.
For respondent number 6. Because he entered on, my lord, 22nd, 8, 2023.
What is that?
And there is a tactics for lingering the
appearance
case.
on behalf of respondent number 6, no?
Obliged, Lordship. Date may be given.
No, let it come up.
7.
Yes, Sakya, counter has come.
My lord.
Have you filed your affidavit?
No, my lord. My lord, our instruction is that, my lord, we have to consider the special family pension, my lord. But we are requested to the concerned director under administrative department to furnish the service book, my lord. Duplicate copy of the service book, my lord. That was communicated on February, my lord. Till that, my lord, service book hasn't come from the director. They have to reconstruct it, my lord.
Regarding that, man, I do not have the instruction, man.
What were you saying?
My lord, we are requesting the service book, my lord, duplicate copy of the service book, my lord. Original service book, my lord, lost somewhere, my lord. It's a old case, my lord. Therefore, requested to the inspector of school, KDC Amingao, to submit a duplicate copy of the service book of the petitioner, husband of the petitioner.
And Chutia, do you have any?
Regarding my service book, man, I do not have the instruction, man. Well, I will take instruction, man, in this regard, man.
Okay.
Aase bana hai dada.
You are appearing for?
Pension department.
Pension department. Okay, yes, have learned counsel for the petition. Mr. PG Cycle and the governor.
Please, I can.
Mr. P Cycle and the governor. Appearing on behalf of the respondent number 4, oblique director of pension. Submits that they have written to the inspector of schools.
Amingao.
For furnishing the copy of the service book.
Duplicate copy of the
Duplicate
service.
For finishing a duplicate copy of the service. MS S. Chutier, then the spending council. Elementary Education Department. Prays for some time to enable her to receive instructions. When do you want?
No, after 10 days, man.
Praise allowed. List after 2 weeks. Let it come. It will come out.
8 and 9.
May I please, lordship?
Lordship, in this matter, we have filed our affidavit today, my lord. We have sent it for filing, my lord.
They have not filed the affidavit yet.
No, we have sent it for filing today. Oh, we will it. So today, during the course of the day, it will be filed, my lord. It's been signed and been sent, my lord. The date may be fixed, my lord. Both the affidavits.
Heard, Mr.
JP Borua on behalf of V. Broadcaster.
J.B. Barua, learned counsel appearing on behalf of Mr. B. Purkayastha, learned counsel for the petition. Mr. A. Fukan,
My lord, for the elementary education.
learned standing counsel, Elementary Education Department, submits that they are filing counter affidavit within the course of the day.
Go to the table.
Stop. According, list this matter. After 2 weeks.
2 weeks. So I appear for the response number 4 in item number 8, your lordship. A Das.
Mr. A. Das.
For response number 4 in item 8.
Council appears for the response number 4
In item 8.
in WBC Q5.
Okay. And the lordship, response number 7 in item 9.
7-1.
And response number 7 in item 9, your lordship.
I appear for response number 3, item 8.
And
Three,
Mr.
SCR.
S. Bora,
SCR.
standing counsel,
SCRT.
SCRT, appears for the response
Response number 3 in item 8.
response number 3.
Apply, your lord. Deeply
Okay,
apply.
my lord.
Then
May it please your lordship. Lordship, item number 10 and 11 both are similar matter. Impugned order in both the cases are same, my lord. Otherwise, lordship,
Why is it coming for orders? Item 11?
otherwise service is complete. The standing counsel for all the respondents' names are also reflected in the cause list, my lord.
Are we given us?
It can be fixed for admission.
34. That is more. Well, so far as these petitioners are concerned, pursuant to the interim order passed by this honorable court, they appeared in the exam. And my lord, both have, they could not, my lord, pass out in the exam. That's my impact. Remember, whoever,
And I to first time this, 9th semester. 9th semester first time appear for this.
9th semester behind.
They appeared for first time. That is different case. Proceed case. So they appeared for first time.
You have been permitted to appear for the exam.
Lordship, earlier we were permitted to appear in the exam, my lord, in the 9th semester.
What is the order sheet?
My lord. Order dated 22/2/2024. Otherwise, my lord, the case is covered by the order passed by this honorable court on 14/5/2024, lordship, by this honorable court. Wherein, lordship, this honorable court held that we are to be governed by 1997 regulation, wherein the upper cap limit of 10 years not there. And the petitioner is covered by that order, lordship. That has been the constant stand of National Medical Commission, lordship, which is the regulatory
Got your
authority.
instructions, my dear?
Lordship, in this set of matters which have been come in, my lord, the honorable court on earlier occasion has directed that owing to the circumstances and the situation of all the specific petitioners, my lord, that specific written instructions are to be placed on record on behalf of the NMC, my lord. What my learned friend for the petitioner is mentioning, that is the order dated 14/5/24, whereby lordship had passed a similar order, my lord. But that was based on the written instructions after scrutiny of the position and entire documents of the petitioner. And my lord, interim relief is already granted, my lord. They've appeared in the examinations. My written instructions are yet to come, my lord. So I pray for another 2 weeks' time, my lord, and the written instructions will be placed and the matter may be disposed of in finality, my lord. Subject to, my lord, what my learned friend for the department and university has to state.
In that case.
My lord, I have some difficulties because as my lord has, my friend has submitted that I could not successful in the last exam which I have appeared, lordship. For that case, lordship, I have to appear in the supplementary exam, which is from lordship 3rd of June, my lord. If this court permits me to appear in the supplementary examination, which your lordship has already.
Are you sure that the petitioner has?
Yes, my lord, written instruction is there, man.
Let us see what does it say. Have you applied for the supplementary exam?
No, lordship, after declaration of my previous result, I can apply, lordship. They have not declared the result. That is why in the previous order which I have submitted.
Was there a bar not to declare result?
There was no bar, my lord, but they have not declared. That is why, lordship, in previous order, this honorable court has categorically directed them to declare the result in case of other petitioners. There was no bar, my lord, as such.
Yeah, item number 10 is Tariq Hussain. 11 is my lord Procedural Islam Mandal.
My lord, this is the last semester, lordship, 9th semester.
So results have all been declared except the petitioners.
Then my lordship will pass an order today to at least declare the result.
And lordship, I may be allowed to appear in the supplementary examination, lordship.
Is there supplementary examination?
That my lord,
Lordship, it is from 3rd of June, my lord. I have
If it is
instruction,
there, my
lordship.
lord, already my lord, in that case, my lord, you may be allowed to participate because in the earlier occasion, the interim was there. No point keeping it, my lord.
Okay. In item number 10, Tariq Hussain, huh? Item 10, WBC 955 2024. Heard, Mr.
R. Karim, my lord.
R. Karim, learned counsel for the petition. Stop. Mr. D.K. Bhatia, learned standing counsel for the National Medical Commission. Public response number 6. Prays for some time to enable him to receive written
instructions, specific written instruction.
prayers allowed. Para. Mr. B. Gogoi, learned standing counsel, Health Department, has produced the communication. No, you are not Health Department.
My lord, no, help me. This instruction has come from the university. University is also a party here in my lord.
So in the Health Department, has produced a communication dated 10/5/2024,
Furnished by the my lord Sankardev University, that may be recorded.
written by the Register Srimanda Shankara Devi University of Health Sciences, wherein it is stated that the petitioner felt in the apert subjects. Stop. It is also stated that the result of the entire batch of students have already been declared by the Srimanda Shankara Devi University of Health Sciences. However, the result of the petitioner is kept pending as the matter is sub judice. Para. After considering the communication dated 10/5/2024, the respondent, particularly the respondent number 6. No, not 6.
It will be the principal and DME, Director of Medical Education.
DME is respondent number 2.
It will be the university who has to declare the result. Is the respondent number?
Lordship will say, my lord, 3 and 4.
The respondent number 3 and 4
Principal of the college as well as the university
are directed to declare the result of the petition forthwith. Stop. Para. Learned counsel for the petitioner submits that the university is going to conduct the supplementary examination.
Supplementary examination for MBBS third professional part 2.
For MBBS third professional part 2 from the
3rd of June 2024.
starting from 3rd of June 2024.
Lord.
Stop. Para. Para. After hearing the learned counsel for parties, the respondents 3 and 4. It will be 3 and 4, direction.
Yes, madam. 3 and 4.
Are directed. to permit the petitioner to appear in the supplementary examination of third semester, and what is it?
Third professional part two MBBS.
Third professional, part two.
Part two MBBS.
MBBS examination commencing from 3rd of June.
If he applies for it.
Now, after result, I can apply, Lordship.
Provided the petitioner applies.
Lordship, after declaring of result, I can apply. Before that, I cannot, my lord.
By tomorrow, it will be declared, my lord.
Maybe appear in the students only, huh? Stop. List the matter again after 2 weeks, you want?
2 weeks, my lord. Lordship may fix a date, my lord, as per lordship's convenience.
Okay. That's what, 30.
30 minutes.
Okay. 19th, is it convenient for you?
Yes, my lord. Yes, my lord.
Can it be on 20, my lord? 20 June,
20. Okay.
hearing day.
20.
Oblige, Lord.
The next item is same.
Same, my lord.
Same order?
Same
Same
order, my lord. In the same, my lord, instruction, the name of the respondent, with petitioner in the next item is there.
No,
Yes,
Same order will do, Lordship.
Respondent numbers are same.
same, my lord.
Same respondent, and they are also from the same semester, and impugn order is also same, my lord.
Okay. Same order?
Like, may I keep the instruction?
Yes. Same order.
Oblige.
Oblige, Lordship.
Item 11 also same. Huh?
12, hearing. Part third matter.
How about that motion method? Motion method standing off. Motion method, that was. Who's the standing off?
Maybe zero.
Oh,
Thank you, sir.
You are the petitioner?
No, your lordship, I'm the respondent, I'm for the private respondent, respondent number 4, 5, and 8. On the last occasion, my senior had completed his arguments, your lordship, for the petitioners. And your lordship had directed that the records be called for the TPC which was held.
No, your name is appearing in the petitioner's list.
No, your lordship, I'm for the respondent number 4, 5, and 8.
Is it?
Yes, your lordship. My senior, Mr. Tiwari, your lordship, he appears for the petitioner. Right, assisted by Mr. O. Gogoi. I'm for the private respondents 4, 5, and 8, your lordship.
Okay.
Yeah.
P.K. Tiwari is not there?
He has finished his arguments. My senior has finished his arguments. Now the matter was left for us to argue our case. In fact, your lordship had directed the state authorities to furnish records of the DPC. The records are still not here, but I can submit, your lordship, whatever.
Let the records come first.
Yes. Yes.
Who appears for the other side?
My senior friend, Mr. C.K.S. Borua, appears. On the last 2 occasions, he appeared. There was a direction for him to produce the records.
Where is that? Is the standing counsel?
He's appearing for respondent number 1 and 2, your lordship. For food and
Food civil supplies.
Yes.
Yes, sir.
Yeah, I'm for a petitioner also.
Yes.
We have finished our part. The food inspector, they have to produce the document.
What year you are appearing for?
No, my lord, I'm waiting for the subsequent matter.
Okay.
The only issue here, your lordship, the issue in gist is the petitioners are promotees to the post of inspector. I am a direct recruitment. Now the rules say that in a particular year, if promotees are promoted and the recruitees are directly recruited, then the promotees will have a superseding effect of seniority over the promotee. I was recruited in the year 2012. The promotees, without disputing the fact that there was vacancy in place, they were promoted in the year 2013 pursuant to a process which was started in 2012. So I had gained seniority, which has been challenged by the petitioner. The rules are clear. The decision is clear. The fact that I was promoted, they were promoted and I was recruited in 2 different years, succeeding years. Your Lordship had sought to inquire as to why the DPC, which was sought to be held on 2 prior occasions, was first cancelled. And thereafter, the process culminated, having started in 2012, culminated in 2013. So pursuant to that, your Lordship had sought the records.
Yes.
That is the only extent to which the matter needs to be heard. It's an administrative decision that the authorities have taken. That my stand is clear, your Lordship. And I understand that the records are not here, might not be here.
No, where's? Yeah, two, the records as well as the guidelines for holding of DPC.
The guidelines will call for.
Yes. Yes.
What government advocate? CKS Borough,
Yes, Borwa, he is appearing them.
where is he?
Perhaps he is not available in court, my lord. I tried him. His number is not reachable. Can it be taken up after some time? Let to confirm from him.
He's not here. As far as I'm
If
aware.
he's not in.
May pray for take up any other time.
There's one more instance your Lordship might be interested to look at. Paragraph 17, your Lordship. Just one for a moment. Here. Paragraph 17
Of the writ petition.
of the writ petition, your Lordship.
Yes.
Paragraph 17. Your Lordship would see that if I be permitted to read, your Lordship, just one paragraph. That the meeting of the selection committee was finally held on 26/12/2012 and it recommended the promotion of all those persons whose names are found mentioned in the WP message dated so and so, which also included the present 8 petitioners. However, there was inordinate delay in processing the matter further after recommendation of the selection committee. It was only by later dated so and so that the government of Assam communicated the concurrence of the personnel department and the WPT and BC department. The concurrence had happened in the year subsequent to 2012, and they have not been made a party. My humble submission, your Lordship, it might so be in order that what took their recommendation that particular point in time, because the authorities' recommendation was done in the year 2012 itself, and had that happened, then they would not have had a concern for initiating this writ petition. The personnel department and the WPD department, they concurred in the subsequent year, which ensured that they were promoted in 2013. And my humble submission, they are not being made a party. I think the response might be necessary in that regard from them. That is subject to my humble submission, your Lordship. I'll leave it to your Lordship.
Your Lordship will call for the record will display.
The
record will display.
Let the records come.
When is it
coming?
Long-standing matter, Lordship.
Well, he is coming. After some time.
Okay.
If I may submit, your Lordship, if the matter can be taken up on any subsequent day, subject to if the records are here. I don't understand the records might be here because in the last occasion the records were not here.
Okay.
Any day.
Yeah, Google.
Yeah, Google and the council petition.
Let it be on the 6th, your Lordship.
Yes.
Also heard Mr. M. Sharma.
M. Sharma, your Lordship.
Then the council appearing for respondents.
4, 5, and 8.
4, 5, and 8.
Yes.
Stop. On request made on behalf of Mr. CKS Bara, then a government advocate. List the matter when do you want?
6th.
Any day is fine. Any day.
Let it be on 6th, your Lordship.
Okay, 6.
I'm grateful, Lordship.
34, motion.
May it please your Lordship. Lordship, this matter also pertains to MBBS student, but he is the student from Jorhat Medical College, Lordship. Lordship, the impugned order here in this case was already challenged before this honorable court in previous cases, Lordship. And this honorable court already set aside and quashed this impugned order, Lordship. That your Lordship will find at page 56, my Lord. Page 56. Relevant portion, your Lordship will find at page 59. page 59. Second para and third para, my lord.
Yes. Then
Lordship, here the petitioner is aggrieved by the impugned order, Lordship, wherein Lordship petitioner is debarred from appearing in the MBBS examination, Lordship, which is to be held from 3rd of June, my lord. Yesterday, Lordship, another case was decided by this honorable court, wherein interim order was there, Lordship. Similar order will do.
with the impugned order,
Lordship. Your Lordship will find the impugned order at page 26, my lord. Page 26. The petitioner is at serial number 2. In respect of other student at serial number 1 and 3, this court has already given order.
when were you admitted?
Yes, Lordship. Lordship, here in this case, I was admitted on 3/7/2020 2014.
Yes, my dear.
My lord, same situation, my lord, with regard to yesterday's petitioner, and one, my lord, had earlier disposed of, because with regard to that matter, we had instantaneous instructions. My lord, at this stage, my lord, possibly in my humble understanding, order in the light of yesterday's order would be sufficient, and both the matters may come up, my lord, together. Similar line of yesterday's order, my lord, would suffice. I would get the written instruction and place them before your lordship.
That can be done.
Mr. R. Karim,
R. Karim, my lord.
learned counsel for the petition. Stop. By this writ petition, para, the petitioner is asserting the communication dated 20/2/2024, written by the Controller of Examinations, Srimanta Shankara Devi, University of Health Sciences, and addressed to the Principal, Jorhat Medical College, Jorhat, informing that the petitioner, along with another 2 students, cannot appear in any further MBBS examination as per the NMC regulations. Stop. In the said communication dated 22/2024, the name of the petitioner appears at serial number
2, my lord.
appears at serial number 2. Stop. It is the case of the petitioner that he was admitted in the first year MBBS
Lordship, in the year 2014, my lord.
that he was admitted in the
2014, Lordship.
that he was admitted on 3/7/2014. And therefore, the gap of 10 years is not applicable to the petitioner. Correct?
Correct, my lord.
Stop. Issue notice.
Lordship.
Health, Family Welfare. Mr. A. Chalia, Learned Standing Counsel. Health Department appears for the respondents 1, 2, and 3. Jorhat Medical College also?
Lordship.
1, 2, and 3. Stop. And who appears for this Srimanta Shankar Devi University?
Lordship,
I.
B. Gogoi will be.
Gogoi appears, Lordship. Lordship may record his petition.
Mr. B. Gogoi,
Four and-
Standing Counsel,
4 and 5.
Srimanta Shankar Deva University of Health Sciences appears for the respondents 4 and 5. And Mr. D.K. Baite, Then standing council NMC appears for the respond number 6. Stop. Notice on respondents are complete. Stop. How extra copies of which petition be furnished to the learned council appearing for the respondents. After 2 weeks, we'll have it.
Yes, my lord.
List the matter after 2 weeks, along with the WBC number.
Yes.
2780.
2780.
Public 2024. Stop. Para. In the interview, comma, the respondents, particularly the respondents
3 and 5, my lord.
3 and 5,
Lordship.
3 and 5. Oblique the principal Johar Medical College and the controller of examinations, comma, Srimanda Shankardeva University of Health Sciences are directed to permit the petitioner to provisionally appear for the
Lordship, MBBS second professional.
second professional MBBS examination
Lordship.
scheduled to be held with
3rd June.
with effect from 3/6/2024.
Oblige the lordship.
Provided they duly apply.
That you will-
Having this certified copy, we will definitely apply.
Lordship may fix this matter because Lordship, these are the same tune of the matters which Lordship have fixed on 19th, my lord.
It was fixed on 20.
20th, my lord, subsequent 20th. So, my lord, if these matters come, my lord, these are from a different institution, but the issue is same, my lord, possibly the similar orders.
Okay,
But these may also be fixed on 20th. my
list
lord.
the matter instead of 2 weeks, you say on 20, huh?
Oblige the lordship.
All the matters may be dealt with. Deeply obliged, my lord.
14 to 17 of daily hearing.
May I please as the lordship?
All parties are represented.
My lord, service is completed and my lord, the private respondent has also appeared. The last occasion, my lord.
Higher education, you are free.
Yes.
Thus, then governing body, Bharkhetri, respondent three.
My lord, I think that governing body has also filed an affidavit also. Is on record, my lord. Affidavit by one Mr. Akan Chaudhary.
And the private respondents?
My lord, in the first petition, my lord, that is WPC 6534 of 2014.
Mm.
My lord, we are challenging and speaking order passed by the Director of Higher Education, my lord. Here is no private party is affected. But but in the rest of the cases, my lord, that is an appointment order is under challenge of one private respondent, my lord, who has been recently appointed.
Respondent 5.
My lord, my lord. So if my lord may be pleased to take up item 14 today, my lord. And once my lordship was also pleased to hear the matter, my lord, long back, my lord. It needs.
But can we continue without them?
Lord, this item number 14, we can continue, but the rest, their presence is required, my lord, to be fairly, my lord.
Then what do we do?
Then my lord can hear this item number 14, my lord.
Then if they are not there, I have to keep it part third again.
My lordship can keep it as a part third matter, my lord.
So many part third matters are there. Then
My lord.
you are appealing for?
Thus.
Huh? Guwahati University.
What university?
Guwahati University is a
Election committee. Election committee.
PG Fugan. For the respondent?
In one of the cases, my lord, the selection committee, which has, my lord, selected this private respondent as a principal, my lord, some representation from the Guwahati University was there, my lord. File kita korbo, file kita. Because, my lord, this 6534 is a very old pending matter of
Yes.
2014, my lord.
Mm.
What has happened, my lord, recently there is an interim order operating in this petition, my lord, that the status quo as regards the post of the principal shall be maintained. Subsequently, my lord, the governing body approached before my lordships and with a modification prayer, and that order of status quo had been modified, giving my lord liberty to the governing body to go ahead with the selection process of the principal, my lord. And accordingly, they have conducted the selection. And although there are lots of violation of the procedures and laws, so my lord, therefore we have subsequently challenged the selection and appointment of this private respondent. That's why, my lord, this 2014 matter had been clubbed with the recent 2022 and 23 matters, my lord. But, my lord, in 2014, my case is very limited, my lord. That an speaking order has been passed, wherein, my lord, it has been held that as my appointment as a principal in the said college is beyond the cutoff date, that is, my lord, 31/12/2010. The cutoff date is 31/12/2010, my lord. That's why my service and post as a principal cannot be provincialized, my lord. That is the speaking order they have passed. Now, that speaking order is under challenge in 6534 of 2014, my lord. Now, if my lordship may be pleased to hear this matter, my lord, and satisfied that yes, we could make out a case, then, my lord, if that speaking order is interfered with, then, my lord, the provincialization scope of myself as a principal of the college may come up, my lord. That is the issue, my lord. But, my lord, to be submit fairly before my lord, in the rest of the cases, the presence of the private respondent is required, my lord.
So the private respondent is presently holding the post of principal.
Presently working, my lord, presently working. And, my lord, in the subsequent petitions, my lord, their presence and they are required to be heard, my lord. But we have not been informed, my lord, today that they are not going to present today. Or,
No,
my lord,
there's no
my lord.
circulation of.
Mentioned memo has also not been circulated, my lord.
Yes. Yes, thus can we proceed?
Our part, if the K Gogo will argue, he takes in another court. If he start, he can start his part.
Gogoi will argue the matter. I saw him just now.
Yes, he is legs in another court. He just came here.
Then let us take up after some time. After some.
Or if the respondent, private respondent is also a party here in this case.
6534. Subsequently, they have
They
implemented.
have been implemented, matter.
In which
6534, my lord. 6534.
They have there is also a private.
Subsequently, they have implemented themselves, my lord, to get vacation of the interim order, my lord. My friend is correct, my lord.
Oh, yes, the
My-
private respondent.
Their presence.
And anybody is appearing?
Today, I have
Name
not.
is showing in the cause list, but nobody is.
No, I know.
Respondent 6 and 7.
My lord. Bhaskar Kalita is the, my lord.
R. Talukta.
D.K. Das, senior counsel, my lord, Mr. D.K. Das appeared. Or Mr. Bhaskar Kalita, my lord, who has been appointed as a principal, my lord.
Then we can't hear it.
Then, my lord, A short date may be given, my lord, because we have the urgency, my lord.
Heard Mr. Bhuyan and council for the petition. Also heard Mr. Esdras, then standing council, higher education. And Mr. PG Fukan, then standing council, Guwahati University. Stuff. None appears for the private respondents. In the interest of justice, list the matter again on. Vote.
My lord.
We'll have it on.
Fourth.
You give your convenient date.
Sixth of,
Six, I've fixed many cases.
and let it be on fourth, my lord. Well, election result for the obligement.
18.
My lord, may I kindly see the last order?
Yes.
Lordship, in this case, K. Gogoi is appearing, Lordship. And they can proceed and Gogoi will come if Hamid is reply, Lordship. They can proceed, Lordship. And Gogoi will come and submit.
What do you say?
Yes, I can proceed. Subject.
And how about the respondent 3 and 10?
Oh. No, they have appeared. And the principal has also filed affidavit, also engaged advocate.
Who is the counsel?
Borgohai, not Borgohai. I got a position.
2017 matter.
Yes, and that's a lordship object last time, then no further date would be given.
Is she around in the court premises? This, no, this B. Borgohen.
Oh, I don't know. No, B. Borgohai. I've not seen.
Or Shyamal. Shyamal.
Their names are there. By name now.
Because if you dispose the account, they'll come for review.
That's it.
But my lord, they are regularly irregular, my lord. Kindly see the series of orders. So
Okay, we'll fix another day. We'll pass the next party order. Heard Mr. M.U. Mahmood, Learned Counsel for the petitioner, as well as Mr. K. Gogoi, Learned Standing Counsel, Higher Education Department for respondents 1 and 2. None appears for the respondents 3 and 10, despite their names being reflected in the cost list. But on 14/5/2024, none appeared for the respondents 3 and 10. And this court directed that there shall be no further adjournment to the next date fixed. However, as none appears for the respondents 3 and 10 today, list in the interest of justice, list the matter again on. We'll give a date. When do you want?
third.
Leave it on 11th of June. 2024. On which date, if the respondents if the counsel for the respondents 3 and 10 are absent, this case shall proceed ex parte against them.
Obliged.
22.
May I please, Your Lordship, my lord, kindly pass over for the time being, my lord.
What?
My senior is on leg, my lord.
Who's your senior?
Dr. P.K. Goswami, my lord. That's you, my lord.
Yes, Fukan is there?
No, he's on the way. We can fix for a short adjournment for the time being.
That's you, my lord. Obliged.
23.
May I please, your lordship? Lordship, here in this case, lordship, petitioner was appointed as a president of School Management and Development Committee, lordship. Yeah, lordship, whatever, after joining the president, lordship, he found that there are many anomalies going in the school, lordship, in the name of midday meal, lordship. But kindly peruse the page 29, lordship.
All parties are represented here also? All are represented. 1 minute. Secretary U Sharma. And SSA. You agree? Okay. Inspector Schools, Deputy Commissioner Barman, and respondents 7 and 8. Guyan.
My lord, I am for the respondent 7, my lord.
Hmm.
And I am for the 8.
8. Okay, proceed.
Lordship, Annexure 1, the appointment letter, lordship. The petitioner was selected as the president of
1 minute.
Annexure 1, page 16, lordship.
Hmm.
The petitioner was appointed as a lordship president of School Management and Development Committee, lordship. Lordship, what I mean thereafter, lordship,
Who's the president? Zakir Hussain.
Zakir Hussain, lordship, as page number 17, lordship.
Hmm.
Lordship, thereafter, after joining lordship, the petitioner found that there are many anomalies going in the school, lordship, in the name of midday meal and others, lordship. So what I mean, lordship, at Annexure 4, page 26, lordship. Lordship, petitioner, not lordship, at Annexure 5, lordship, page number 27, lordship. Lordship, petitioner found that there are more than 100 bag of rice, lordship. Lordship, which are for midday meal, lordship, which are damaged, lordship. Thereafter, the petitioner informed the concerned authority about the anomalies and the lordship going in the school, lordship. Lordship, thereafter, the authorities page number 33, Annexure 7, lordship.
No, page 27. What is the address?
Lordship, the petitioner informed the block cluster resource center, lordship, that there are more than 100 bag of rice in the school are not presently in the position of consumption, lordship. At page number 29, lordship, the photograph of the rice, lordship, rice bag, lordship. The more than 100 bag of rice are damaged, lordship, in the school, lordship. Then thereafter, lordship, at Annexure 7, lordship, the authority has issued so cause notice to principal, lordship. That is page 33, lordship. Page 33, Annexure 7, lordship. So cause notice was issued, lordship, regarding the complaint of the petitioner, lordship. That is the president of the school managing committee, lordship.
Okay. No, show cause notice was issued to whom?
To respondent number 8, Lordship, that is the principal, Lordship. Lordship, what I mean the impugn, impugn
You are
order-
the president.
I am the president, Lordship.
Oh.
Lordship, what happened on 13, Lordship, we have received one notice through WhatsApp, Lordship, that the president was removed from the post, Lordship. The impugn order is page number 11, Lordship, page 47. So my prayer is that, Lordship, without issuing any so-called notice, without Lordship, without any so-called notice, I am removed from the post, Lordship.
1 minute.
Without serving any notice, without any so-called notice, Lordship.
No, what is this page 7, annexure 7, page 33?
It is a so-called notice issued against the respondent number 8, Lordship. Against my complaint, Lordship. Petitioner give complaint against the Lordship anomalies going in the school, Lordship. Thereafter,
After this show cause, what happened?
after the so-called notice, Lordship, we have informed other respondent, other authority regarding the anomalies going in the school, Lordship. Thereafter, suddenly, the petitioner was shocked that on Lordship, on 13/9/2023 through WhatsApp message, we have received one notice that I am removed from the Lordship post of the president, Lordship. Without some Lordship, my prayer is that without serving any notice, without Lordship issuing any notice, so-called notice, Lordship, how can remove my post, Lordship?
Yes.
Yes, Lordship.
So
Although
you
Lordship,
you are challenging this 9/9/2022 order.
9/9/22 order, Lordship.
Five minutes.
Name was initially not reflected. I will issue the notice. I accepted the notice. Since my lord, our affidavit has not been filed. And my lord, the impugn order has been issued by the district authority, with otherwise my lord, Samsa authority. So my lord, sometime my lord, the weekdays, my lord, I thought. Because it seems my lord, there are some complaints that is presidency has been my lord, cancelled.
Then how is it coming for the hearing?
But probably it has been brought by mentioning my lord. The other respondent has filed the affidavit.
You have not filed your affidavit.
No, man. Check the record.
Okay, heard, Mr.
B. Borgohain, Lordship.
B.
B.
B. Borgohain, learned counsel for the petitioner. Last occasion you were there, Gogoi,
Fine.
for respondents 3 and 5, and the petition was allowed to be admitted.
Yes.
You could have mentioned that they.
My lord, I'm
3 and 5.
You have for 3 and
3 and 5.
secretary. Also heard Mr. U. Sharma, learned standing counsel, secretary education. For the respondents, 1, 2, 1, 2, and 6. MS D.D. Barman, learned government advocate for the respondent number 4. Mr. A.R. Buyan, learned counsel for the respondent number 7.
7.
And Mr.
M.A.I. Hussain.
M.A.I. Hussain, learned counsel for the respondent number 8. On request made by Mr. B. Gogoi, learned standing counsel, learned standing counsel.
Yes, sir.
SSA. For the respondents,
3 and 5.
3 and 5. How much time you require?
Not to 10 days, but 2 days after 2 weeks.
2 weeks time is allowed to file contract.
The date may be fixed, Lordship.
Based on 20 June.
Lordship. Master.
24 to 29.
My pleasure, Lordship. Lordship, by this petition, Lordship, we are primarily aggrieved by imposition of two conditions in our provincialization order, Lordship. If your Lordship may kindly come to the provincialization order at page 20.
1 minute.
Lordship.
Now, in this method, B Kaushik supposed to be appear, but my lord is on leg, my lord. My lord, maybe come some other day, my lord.
No counter has been filed?
No counter has been filed, Lordship. And on the last occasion, Lordship, this honorable court was pleased to direct that in the event no counter is filed, the matter will be heard on the basis of materials available on record. Now, Lordship, the salaries of the petitioners are withheld since 2021.
Then, where's Kaushik?
And
B Kaushik is on leg, my lord, in another. Some other day.
And Lordship, as coordinate base of this honorable court, in a similar matter, containing the same exact conditions, those have been set aside. And
That was considered by this court on the last occasion. Then we will go for a hearing.
Lordship.
But Mr. A. Chakravarti, learning counsel for the petition. On request made on behalf of Mr. B. Kaushik. Learner standing counsel,
Secondary education.
secondary education, list the matter, when?
The 2 weeks, my lord.
But date may be fixed because they're without salary, working without salaries, Lord.
On 18th June.
Obliged, sir.
31. Yeah.
May I please, your lordship? My lord, the record was called for, my lord, and my lord, the Musahari is handling the matter, my lord, and she is out of station, my lord. So, my lord, 2 weeks, maybe.
My lord, the situation is very pathetic, my lord. One petitioner has died, my lord.
Then?
And another one is in a bedridden condition, my lord. Yesterday night rang me update whether what will happen to these cases. This case,
How
my
many
lord,
petitioners are here?
my lord, 4 numbers of petitioners, my lord.
Then,
My lord, already we have filed our affidavit, my lord.
Affidavit is there, my lord.
affidavit is there.
But record was called for, my lord.
Yes, my lord. My record was called for by this honorable court, my lord.
And the Musahari is handling the matter, my lord, and she is out of station due to her relative marriage, my lord, in Majuli. So,
My friend can take up, my lord. Such type of situation happens with us also, my lord.
he will come, my lord. He will come.
A short date may be given.
But yeah, beyond learner counsel for the petition. On request made on behalf of MS D. Mushahabi, learner standing counsel secondary education. When do you want?
After 2 weeks, he will come in the meantime.
2 weeks. Marriage takes for 2 weeks or?
After 10 days, my lord.
Yeah, weeks after time can be taken up, my lord.
And record also required, my lord.
Okay, we'll have it on 11th.
11.
Obliged, my lord.
32.
32 amount. Yeah? Yeah, almost one and a half. Huh?
What? My lord, in this matter, standing counsel Mr. B. Chaudhary appears, my lord. He is in the midst of a parted matter, my lord. It will take some time, my lord.
P. Chowdhury,
My lord, SSA counsel.
SSA. Last occasion, P. Nayak was appearing.
P. Nayak was appearing.
Where's P. Nayak? Counter has come.
We have filed our petition, my lord. Yes, my lord.
Only SSC is the necessary party.
Yes, my lord, the issue is very limited, my lord. I have been, my lord, neither suspended nor terminated, but I have not been allowed to join. And they have said, my lord, that they have initiated some proceeding regarding some allegation of, my lord, bribery, that I have taken some bribes from some of the teachers for doing some work. That is the allegation. Now, my lord, what is happening? As a result, my lord, I am not getting any subsistence allowance, no salary from last, my lord.
You have not been suspended also.
I have also not been suspended on the pretext that I am a contractual employee. So suspension rule is not applicable, but record speaks otherwise, my lord, that they have issued a circular wherein they have said that the Assam Services Discipline and Appeal Rules is also applicable for this type of, my lord, contractual employees, my lord.
Yes, then.
So, my lord, some if now, my lord, in absence of my learned friend, my lord, some interim prayer, my lord, we have made that at least for survival of the family of the petitioner, my lord, if some subsistence allowance is provided.
No
Let the
issue.
standing council come, my lord, then. If question of interim arise, my lord.
When is he coming?
Usually meets our quarter matter, my lord. Will take some time, my lord.
Monday or Tuesday, my lord.
But yeah, Buyan and the council for the petition on request made on behalf of Mr.
Beach already.
D. Chowdhury, London Standing Council, SSA.
SSM, my lord.
List the matter again on 5th.
Can it be on next week, my lord, Tuesday, my lord? Some urgency is there.
That's right, 5th.
My lord.
Is a Wednesday. Or you want to have it on a hearing day?
Hearing day, my lord.
4th.
My lord.
Hello, bless, my lord.
Obliged.
33.
Where the petitioner is seeking the benefit of old pension scheme. Well, in brief, my lord, I'll just point out the points involved, my lord. They were.
1 minute. Today, none of the parties are properly represented. Let us see your matter, what is their parties are represented.
Well, if the other side doesn't appear, my lord, your lordship will hear it expert.
Who appears? Finance? School education?
This is education, my lord.
Secondary, you are there? And finance? Your case is that with regard to the old pension scheme.
Old pension scheme. Because your advertisement was 96. Ultimately, my lord, they joined in the appointment orders were issued 2011 because of court's direction. And they were court's direction, but there is a decision of this court. If the processes started prior to the 2011, 2005, my lord, they are entitled to get pension. Now they are saying that at the time of joining, you have given an undertaking that you will not claim for the old pension scheme. So on that is the point, my lord, whether my giving undertaking will deny my right of getting the old pension scheme.
Yes, Sharma was finance.
And the chief minister has also issued, my lord, one minutes, my lord. The government of Assam will consider extending the benefit of old pension scheme to those employees who joined the government service after 2005, but the recruitment process for the concerned post was started prior to 2005.
Let us see.
First part. That is in tune with the, my lord, the various judgments of the court. First part, number 1.
When was this held? 15/3/2024.
Yes. They are undertaking, my lord, they are in the upper hand. So there also I got a judgment that being in a upper hand, my lord, you cannot compel a employee that you will give undertaking and you will forego your right. That cannot be the position.
Have you got a copy of this?
No.
Give him a copy.
But besides this, my lord, is covered by decision of this court. Since the joining process, my lord, advertisement was there in 96. And my lord, the delay is because of their own fault. And ultimately the petitioners were appointed on the basis of the judgment process.
Yes, Chalia, you're ready?
Lordship, here, item number 33. Here, Lordship, our name we have missed out on this item, Lordship, our name is not shown, Lordship. This item.
My lord, finance is not that, my lord,
Lordship,
not that relevant.
here, Lordship,
With regard to all pension scheme.
yes, finance is
They are implemented, respondent number 3.
Yes.
But main part is commissioner because the impugn order has been issued by
we
the
are a party,
education
Lordship, but we have missed out, Lordship. If Lordship, today, Purnima or Lordship, some time will be required to prepare, Lordship, because today we have not been able to. Secondary teacher.
No.
Okay. This is a short matter.
Lordship.
There were recruitment started in the year
96.
advertisement.
Yes.
Then because of some court cases here and there and litigations,
Yes. Ultimately were appointed in the year 2011.
11.
Lordship.
And here the CM has also given an assurance that for
And there
those,
is a division bench judgment also.
yes, plus a division bench judgment. So you study this matter, come back.
Lordship, short date maybe.
Okay, Hart.
Next
Mr.
Tuesday, my lord.
B.D. Das, so many cases are fixed. Learned Senior Counsel, assisted by Mr.
Sharma, H.K. Sharma.
H.K. Sharma, Learned Counsel for the petitioner. Also heard Mr. U. Sharma, Learned Standing Counsel, Secondary Education Department. On request made by Mr. A. Chalia, Learned Standing Counsel, Finance Department. When do you want?
Lordship, after 10 days, Lordship, we required some instruction so that we.
Please list the matter on 13th. 13th of June.
Lordship, our names maybe.
Registry is also directed to reflect the name of the Learned Standing Counsel Finance Department in the cost list.
It will come at the hearing to
It will come in the hearing.
Okay.
Hearing.
This is the last matter. Yes, where's the standing counsel? This is the problem today, I don't.
He was present on that day, my lord. And the matter was fixed for hearing. My lord, in this case, I have submitted my list.
Yes, counsel. Where's your senior?
Lordship, he's coming. Due to some personal difficulty, he is not reached the court. Within the court. Lordship, for 10 to 15 minutes.
I can't wait like this. Court is not supposed to wait for the counsel. Counsels are supposed to wait for the court.
But due to some personal difficulty, he is not direct.
Then we'll fix a date. I can't keep on. This is the last item, isn't it?
My lord, in that case, observation may be made, my lord. Only last day as the last chance, my lord.
Heard Miss Dr. P.K. Goswami,
Yes, my lord.
Learned Counsel for the
They are always taking time, my lord.
on request made by Miss on behalf of Mr. P.G. Fukan, Learned Standing Counsel, Guwahati University. When do you want?
Is the opening?
Is it a parted matter? No.
It was hard, but your lordship was not recorded as part.
Release the matter on 11th. It is made clear that there shall be no adjournment on the next date fixed.
My lord.
Much obliged.